Donna Tobe. I'm appearing on behalf of myself.
Ms. Tobe, I had issued a bench warrant for your arrest for failure you to appear at a show cause hearing, which I know that you had notice of. You filed a motion in this case to remove and expunge the court's order for contempt and the warrant for your arrest. That is your motion before the court today.
Yes.
Go ahead.
So,
Right off the bat, did you catch that? She explicitly says she wants this on the record and for YouTube. That's a bold move. This isn't just a legal defense anymore, it's a reputation battle playing out in public. But here's the question, is the courtroom really the place to manage your online image?
I would like to put this on the record for my own purposes and also for YouTube. The YouTube that was recorded when you issued this bench warrant has been used against me in my professional capacity and for other cases, and therefore I would like to have this on the record.
Have what on the record?
What I'm going to tell you now in my defense.
Go ahead.
Okay. It's my motion. The following enumerated facts support my motion to remove and expunge from every record, including the YouTube video: A, your order for contempt, your warrant issued for my arrest, and your order to hold me under arrest on $10,000 cash bail. I received the judge's final docket for hearings set for Tuesday, February 3rd, 2026 at my email address on Monday, February 2nd from Ms. Wiedling. I opened the email the morning of Tuesday, February 3rd, because I am a party in a completely different case before this court, and I looked for something on that case on the docket. To my surprise, the docket for 2 p.m. that very afternoon had me listed for a show cause hearing on a case for which I am neither a party nor an attorney, not having had any notice of appearance for this.
Now this is where things get interesting. She's arguing improper notice, basically saying, I didn't even know I was supposed to be here. And in legal terms, that's huge. If proper notice wasn't given, the entire contempt finding could be on shaky ground. But judges don't like being told they got it wrong, so this could go either way.
This hearing, I was not able to get to the court in time, so I sent Ms. Wiedling the email, which I attached on my motion as Exhibit A, explaining that to the court. I receive all of my business mail at Post Office Box 1283 in Ann Arbor, Michigan 48106. I check my mailbox weekdays after 5 p.m. On Thursday, February 5th, 2 days after the unnoticed show cause hearing on the court's February 3rd docket, I sent Ms. Wiedling the email and photos provided at Exhibit B. The email describes what I received that morning, Thursday, February 5th, 2026, in my post office box, 2 days after the hearing was held. The photos included with my email to the court are of a motion, affidavit, and order to show cause signed by Judge Simpson, along with the postmarked envelope they were mailed in. Exhibit C is hard copies of those legal papers and the envelope. The motion at number 2, page 1, states, I am being held by the judge in contempt for filing a pleading without my client's knowledge nor being the attorney of record. At number 3 on page 1, Judge Simpson requests an order to show cause why I should not be found in civil contempt of court. Can you attach it for me? Thank you. At item 5, page 2, I am ordered to appear before the court on February 3rd at 2 p.m. At 7 on page 2, of the order to show cause, it states that a copy of this order must be served by mail on the person ordered to appear, which is me, at least 14 days before the hearing, which had been set for a hearing on the docket for February 3rd at 2 p.m. The judge's signature is dated January 20th. The envelope is postmarked January 28th. The date the post office mailed it, which is only 6 days before the hearing date of February 3rd, which is not the, quote, service by mail within 14 days.
Let's break this down. The order required 14 days notice, but the timeline she's presenting shows she got it late, after the hearing already happened. If that's accurate, that's not just a technicality, that's due process. And without due process, enforcing contempt becomes legally questionable. So now the pressure shifts to the judge to justify what happened.
Is required by the judge's signed order. I received the order at my address on February 5th, 2 days after the hearing was held, and only 8 days after it was mailed. Judge Simpson found me in contempt for not appearing. The further facts are that in finding me in contempt for not appearing, Judge Simpson issued a warrant for my arrest and demanded an excessively punitive cash bail of $10,000, or so I was told by a person who was in the courtroom when Judge Simpson put his order for my arrest on the record. Based on what I have provided, the judge's motion and order in the mailing envelope, I am asking for the following relief from Judge Simpson. Please retract, remove, and/or expunge all records of the order for contempt, the bench warrant, and cash bail issued by the judge, so that there is no evidence out on the web that the judge issued the order, the warrant, and the excessively punitive bail. I include court records, transcript records, and the YouTube video of the judge's orders that another attorney alerted me to in cases that I am appearing in 3 other circuit courts, and reissue with proper notice to me the show cause hearing the judge wishes to impose upon me. I am perfectly happy and willing to appear at a show cause hearing if I have proper notice. I did not.
This is your proper notice. You had notice. I will stand on the record that I made that day that you had notice of that.
And there it is, the judge shuts it down. No debate, no back and forth. This is a classic courtroom power moment. The judge is making it clear, I've already ruled, and I'm standing by it. At this point, the argument isn't just about notice anymore, it's about authority.
Hearing, and that you failed to appear.
And
my staff indicated that. You can argue with me all you want, Ms. Tobe. What I will do, though, because you have part of the reason that the bond is set in the amount that it was, is because you had basically been removed from the case, this case. You had filed a pleading, you signed it. Your former client had no knowledge of it.
that is not,
Was delayed.
not correct.
You want to know what? Do not interrupt me, because then there's going to be a whole other problem. Your client stated on the record they did not have no knowledge of it. Defense counsel or plaintiff's counsel had to respond. The amount of the bond is the amount of billings that the plaintiff had incurred based upon you filing pleadings when you weren't supposed to and the delay that you caused. It was set in that amount. What?
Interesting outcome here, the bench warrant gets cancelled, which is a win, but not a complete one. The judge resets the hearing instead of dismissing the issue entirely. Translation: you're getting another chance, but this isn't over. The legal battle just got extended.
What I will do is I will cancel the bench warrant. I will reset your show cause hearing. So here's your notice for April 14, 2026, 9 a.m. Thank you. Have all your witnesses, and if you wish to be represented by counsel, you need to have counsel present at that proceeding.
Thank you.
Are you understood? Am I understood?
Clearly.
Thank you.
Your Honor, what do you say? Yeah, right here.
Yes, in just one moment. That's okay, sir. I think that we have somebody else coming in.
Which one do you want?
Hold on, can you,
Not yet.
where's Bobby and Dave?
Bobby's in the back. I don't know where Nate is. They just asked if somebody could come in.
Bobby's in the back where? Like, the back?
Took Mr. Jackson back. He's back there with Jackson.
Do you need something?
I guess we need Dade. Please.
We'll find it.
Okay, and so, counsel, your appearance, please.
Good morning, Your Honor. Delito Taylor, fee number 8227, was on behalf of the plaintiff, Mark Kubiak.
All right, and, sir, your name for the record, please.
Donnell Hamilton.
Okay, and so Mr. Hamilton and, Mr. Jakubiak, I'm gonna ask you to please place your name on the record, sir.
Mark Jakubiak.
Okay. And so I'm going to have you both please raise your right hands. Do you solemnly swear or affirm the testimony about to give in this matter to be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Yes.
Yes,
All
sir.
right, thank you. Can you have Mark come in? Somebody else can.
He sent Dave, Mark's at the door. He sent Dave a message to, I don't know where either one of them.
Okay, and so counsel, today's the date scheduled for a hearing in this matter. And you have you spoken to Mr. Hamilton today?
Mr. Hamilton and I have not spoken. There's no agreement on this, Your Honor. He did deliver more documents to my office this past week.
All right, and so there is a claim, so Mr. Hamilton indicates that Mr. Jakubiak is not the owner. Is that correct?
I never had proof that he was the owner.
Right, okay, so Ms. Taylor, did you submit proof to Mr. Hamilton that Mr. Jakubiak, Mark Jakubiak was the owner?
In the documents that were filed with the court with the summons and complaint, there is a copy of a warranty deed that should have been sent with him for service that shows he is owner of the property, Your Honor, and I do have that deed with me today.
Okay, well, that I asked if you sent that to Mr. Hamilton since the last court date.
I did not, Your Honor.
Why not?
I just assumed it was in the packet, Your Honor.
Well, Mr. Hamilton seems to not have that information, which is why I expected that was all documents were going to be exchanged prior to today. Sir, do you have a copy of that in your packet of information?
I do. When they sent the court letter from the eviction letter that I got, that's when I was able to realize that it was in that document. But prior to when I asked for it at first, I never knew it. Or
Sir, you have that all in your
I
documentation.
just got it from those paperwork that they mailed. That was from.
Sir,
Go ahead. I'm sorry.
when did you receive those papers?
When I finally went through my mailbox, so I can't remember the exact date, Your Honor.
Was it before your last court date here, sir? On March 6th?
No, it wasn't. I never looked through the whole document, so the only thing I seen was the date of the.
Sir, let me see your packet of information that you received in the mail.
I don't have the packet. The only thing that I brought was the deed that you said.
Okay, and so now you see that Mr. Mark Jakubiak is an owner, correct?
Yes, ma'am.
Okay, great. So, do you have any objection? So, counsel, so had the two of you spoken beforehand, you would have known that Mr. Hamilton agrees that Mr. Jakubiak is now an owner. So now Mr. Jakubiak wants to sell the house, correct?
That is correct, Your Honor. We're just seeking possession only, Your Honor.
Okay, and so Mr. Hamilton?
So the reason why, only thing I was seeking, like I asked Mr. Jubek, was for my security deposit, and I heard what he stated from a couple days after, which was a week after. I also brought to the knowledge that when they rented the property out to me, there was no orders ordered compliance and certification for them to even rent this apartment out to me. So my only problem was just me getting my security deposit back. And I have both documents stating from 2023 of June 28th of violations and also October 22nd, 2025 of violations of no compliance certificate.
Okay, so counsel, Mr. Hamilton's asking for his security deposit back. How much is his security deposit, sir? Sir, how much is your security?
Oh, it's 700 on my lease.
I'm sorry?
700.
700.
Yes, ma'am.
So Mr. Jakubiak's asking for his security deposit back.
Mr. Hamilton's asking for.
I'm sorry, yes.
This is clear the record. Your Honor, Mark Jakubiak has just became the owner when his brother died. The lease agreement was between his brother Francis Jakubiak and Mr. Hamilton. Francis received, if he received anything, we don't know, but there's no receipt of any security deposit being paid. That lease agreement is not between my client and Mr. Hamilton. My client is seeking possession only based since his brother died. He needs to sell it.
Okay, Mr. Hamilton, I need you to pause moving all the paperwork because it's affecting the recording. Okay, just because that microphone's very sensitive. Sir, did you file a counter complaint that you're asking for the security deposit? And for what purpose would you need the security deposit since you have not even relocated yet?
I would need the security deposit so I can be able to relocate. The reason why I'm asking for it back is because the money that I do have is going to be completely drained out my bank account. Because as of right now, like I stated when the last time I was here, I'm going through physical therapy and my doctor has me on limited duty at work right now.
Okay.
So that's one of the main reasons why.
All right, and sir, I can appreciate that, but there's not a legal basis at this point for me to order your security deposit to be returned before you've relocated. Typically, a security deposit can be returned after a person moves out to make sure that the person's entitled to that security deposit. Okay, so I don't have a legal basis, sir, to order Mr. Mark Jakubiak to provide you back with that security deposit. However, counsel, just so you're aware, your client's aware that I'm going to presume that Mr. Hamilton's going to request his security deposit to be returned to him at some point. So I don't know if Mr. Mark Jakubiak is the representative for his brother Francis, or if you are, I don't know, but somebody's going to have to rectify that because that is going to become an issue, it appears. So.
Duly noted, Your Honor.
Okay. All right. So, Mr. Hamilton, I don't have a legal basis to not grant their request for you to relocate.
Could you say that one more time for me?
I do not have a legal basis to not grant the request by Mr. Jakubiak for you to relocate from the home because he wants to sell it.
Could you break that down for me just a little bit more if possible?
Yes. Mr. Jakubiak's the owner of the home.
Right.
By warranty deed. He wants to list the home for sale. He's requested that you relocate. I don't have a legal basis to not grant that request. So if I have a legal basis to not grant it, then I can consider that, but I don't have a legal basis to not grant that. Whether or not it was properly registered or not, that's not for this court at this time. Mr. Jakubiak's the owner of the home. He wants to sell the house. He needs for the tenants to be removed so he can get the house ready for sale and sell the house.
Okay.
Okay?
So what I'm basically saying is I have no problem with that, and I stated that already back in October sorry for his loss, when his brother first passed away. I stated that when he first passed away, I asked him, can you make repairs to the apartment, or can you give me my security deposit back, and I'll gladly move out of this apartment.
Okay, but so you're not entitled to your security deposit to have you move out, right? That's something that happens after you've relocated.
I understand.
Okay.
So the part that I was trying to get an understanding is because, like he did say, the young lady just said is that, I didn't have the lease with Mark per se. It was with Francis, his brother.
Okay, sir, hold on just a moment.
Okay.
At this point, right, unless there's some other agreement, you're going to have to move by March 27th.
I wouldn't be able to move by March 27th.
Okay, why not?
because I'm still I'm living to that break right now. Like I said, I can't really work too much, so I would need more time than.
Okay, what is it that you are requesting for additional time?
I'm looking for about 45 days.
Sir, you've had notice since October.
I have not.
Counsel, if you and Mr. Hamilton would have spoken beforehand, I wouldn't have to go through this exercise right now. Is there additional time that your client's willing to give Mr. Hamilton?
No, Your Honor, my client has not received any rent. He did ask for rent. As he stated at the last hearing, he has approximately $2,100 in his bank account that he has held because he did not pay rent. He has the means to move. My client has a buyer ready to close. We are asking for rent to be issued.
Now shifting to the second case, this is where the human side hits. You've got someone asking for more time, dealing with financial strain, even health issues, but the court is bound by legal standards, not personal hardship alone. It's a tough reality. Fairness in law doesn't always feel fair in life.
10 days.
Okay, well, Mr. Hamilton, I don't have a legal basis to not grant that. You've had notice since October, sir.
Ma'am, I have not had a notice since October. I had the notice when I set the notice, and that's when I asked the mark to fix the property, maintain the property, and then I could pay the rent. That's why I had to file the police report that I submitted towards you, and then with the threats of everything. I tried to work everything out with the mark and then also his lawyer. I filed a police report because I was getting made threats of this.
Okay, sir. I hear what you're saying, but it is not necessarily relevant to the proceedings today. There's not an agreement for another date for you to move out. What the court will do is the court will indicate that I will give you until March 31st. That's 4 extra days. So the court will note that judgment will enter for the plaintiff and that defendant is to relocate by March 31st. No money judgment at this time, and the court's not ordering any, because you're just asking for the defendant to relocate, correct?
Correct, Your Honor.
Right. So there's no money that's owed or anything of that nature, and that's the order of the court.
I'll submit the judgment through NYP filing, Your Honor.
All right, thank you.
Thank you.
All right, have a good day. Have a good day, sir.
Please.
What's that, sir?
And the reason why I was trying to get to, the point that I was trying to get to is this has been a trend with him and his brother before the brother even passed.
Hold on, sir. Tell me how that's relevant
I'm trying to,
Mr. Mark Jakubiak wanting to sell the home.
because at this point it's a retaliation. It's a retaliation eviction.
Sir, the court does not find it's a retaliation eviction.
I'm trying to.
Excuse me, just a moment, sir. Mr. Jakubiak is looking to sell the home. If he doesn't sell the home and he rents it to somebody different and he's not selling the home, then, sir, you may have some type of action. You'd have to bring that back before the court. But at this point, the court's not finding, sir, that it's a retaliatory eviction because